Good morning, everyone. Thank you for um, logging on to this virtual pre-recorded seminar examining the exceptions to Bolam negligence. This is an interesting topic and one which I do think merits re-attention given the seemingly increasing friction between classical Bolam negligence and cases such as Montgomery and Muller. Um, the purpose of today, as I've said in the outline to this, is that hopefully you'll leave having a proper understanding of the decision in Bolam. We'll then go on to address what's known as the Bolitho exception, and then we'll look at cases where the courts have moved away from Bolam negligence. The most obvious of those, which you'll all be aware of, is consent cases. We'll look at cases involving what's known as a pure diagnosis, and we'll also look at the thorny issue of advice given by clinicians, and we'll see if we can draw some conclusions as to the circumstances and scenarios in which the courts will apply Bolam, or where they may move away from that to Montgomery or even Muller. So, what is meant by Bolam negligence? I don't want to go over undergraduate tort law with you all. Bolam is a very famous case, but it's often misunderstood, and I find that it's particularly misunderstood by experts when they're giving their reports. It's very often the case that you will see an expert witness effectively draw the conclusion that simply because they wouldn't have acted in such a way that constitutes negligence. That is not correct, as you will all know. So let's look at what Mr. Justice McNair said in Bolam. Now, if you read the decision in Bolam, it's somewhat unusually written as a judgment, but you'll have to remember that this was a direction that was given to a jury, because it was back when civil cases still had a jury. But Mr. Justice McNair said, "I myself would prefer to put it this way, that he is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. I do not think there is much difference in sense. It is just a different way of expressing the same thought. Putting it the other way round, a man is not negligent if he is acting in accordance with such a practice merely because there is a body of opinion who would take a contrary view." And it's that final sentence which is most commonly quoted when people refer to Bolam. So the test very much is a responsible body of medical opinion, and the fact that another doctor, surgeon, or other clinician would not have acted differently is not sufficient to establish negligence. It is a very high hurdle, the Bolam test, for claimants to satisfy. From a defendant's perspective, if you can adduce evidence which shows that a responsible body, i.e. other doctors, surgeons or otherwise, would have acted in such a way, the claimant really will struggle. So let's just look at a common type of example here in how both claimants and defendants will look to analyse a case. Take the example of a GP referral case. So it's a failure to refer promptly or in time. The GP reaches a diagnosis which turns out to be incorrect. A very common type of case in this would be bowel cancer, other types of cancer. There's two real issues, which is, should the GP have considered the diagnosis of X, for the sake of the example, cancer, within a differential diagnosis, and therefore, with a cancer case, made a 2-week referral? Or would a reasonable body of GPs support the diagnosis, notwithstanding that it is correct. Now, the way that it will be framed is important. The claimant will always seek to argue that it was mandatory to consider the more sinister pathology and therefore to make a referral, whereas the defendants will argue that it was a reasonable diagnosis, notwithstanding that it was incorrect. That goes to show the difficulty which even a classic Bolam case can give rise to, especially when it is not straightforward simply to say whether or not other clinicians would have acted in such a way. Okay, so the Bolitho exception was introduced, as you all know, in the case of Bolitho, and it's the opinion of Lord Brown-Wilkinson that really gives credence to the exception. And it is known as the logical basis exception. The court held that there is a requirement for that body of doctors to be reasonable, responsible, and for their position to withstand logical analysis of risks and benefits. So what this means in practice is that the claimant's case will fail unless it can be shown that the defendant's expert falls foul of the Bolitho exception, in that the body of opinion which they rely upon is either unreasonable, irresponsible, or that their position does not withstand logical analysis. It's almost always going to be the logical analysis that will be in question. It's very unusual that you ever come across an opinion which is unreasonable, especially within the context of clinical negligence work. Even with the Bolitho exception, it remains a high threshold for the claimant to reach. In practical terms, it will be difficult to persuade a court that the defendant's expert opinion is either unreasonable or, two, does not withstand logical analysis. Now, the reason why the logical analysis exception was introduced is reasonably self-explanatory, in that unfettered Bolam is too high a hurdle for claimants to satisfy. In the vast majority of contested clinical negligence cases, there will be simply different opinions. You've got a defendant expert saying one thing and you've got a claimant saying the other. Unfettered Bolam would not allow the claimant to succeed. So it has to be right that the claimants can challenge the defendant's expert and say that their opinion does not withstand logical analysis. Okay, let's look now at cases where Bolam does not easily apply. As I've already given you the example of a classic GP failure to refer case, it's not straightforward, and there is undoubtedly a distinction between cases where an individual error was made. The most common example of that would be an iatrogenic surgical error, compared to those where advice is being offered by the clinician, surgeon or otherwise, and a treatment plan is being formed. Can it realistically be said, taking the example of the surgeon who causes an iatrogenic injury, that the test should be whether a reasonable body of surgeons would done as he or she did? It seems illogical, that, because you struggle to find a surgeon that said that effectively making an error during surgery was reasonable. So the question is more whether or not Bolam fits easily with that type of case. Also, it should be considered whether Bolam should apply across the board. Now, undoubtedly, claimants will say no, it shouldn't, bearing in mind what we've already discussed about the difficulty that claimants can often face when looking at a case through the Bolam prism. Okay, let's look now at informed consent and the decision of Montgomery. This is the most obvious example of where the courts have moved away from Bolam negligence, and it's a case that will be well known to all of you. Now, Montgomery is a talk in and of itself, so I will only be taking you through some of the more broader concepts associated with the same. Now, as you'll all know, Montgomery represented a sea change, and it brought about a complete change in the law applicable to informed consent. It moved away from paternalistic medicine as encapsulated within the Bolam test. I'll quote the opinion of Lord Kerr at paragraph 87 for you, because this really is the ratio of the case. The doctor is therefore under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatment. The test of materiality is whether, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. So that seems straightforward, but I can assure you it's not. Consent cases are extremely complex. The area is not helped in general by a lack of appellate court decisions on the application and interpretation of Montgomery. What the 2 points really are, though, is the test of material risk associated with whatever it is, and whether or not there is a reasonable alternative. As we'll come on to discuss, though, Montgomery has a wider application than simply to a classic consent case. By classic consent case, what I mean is a surgeon that fails to inform the claimant of a material risk associated with surgery. Chester and Afshar, whilst primarily concerned with causation, was a good example of such a case. Okay, so the two-stage test was confirmed by the Court of Appeal in Deuce and Worcestershire Acute Hospitals NHS Trust. Those are, and I quote here, in light of the differing roles identified in this involves a twofold test. One, what risks associated with an operation were or should have been known to the medical professionals in question. This is a matter falling within the expertise of medical professionals, and in reliance upon that test, the Court of Appeal cites paragraph 83 of Montgomery. Two, whether the patient should have been told about such risks by reference to whether they were material. That is not a matter for the court to determine. Sorry, that is a matter for the court to determine. The issue is not, therefore, subject of the Bolam test and not something that can be determined by reference to expert evidence alone. And the Court of Appeal cites paragraphs 84 and 85 of Montgomery in support of that. So, is there a limited role for Bolam when looking at that? The question is whether Bolam applies in the first of the two questions outlined by the Court of Appeal in Deuce. And that is what risks associated with an operation were or should have been known. Now, support for this can be found in the judgment of Lady Hale in Montgomery. At paragraph 115, Lady Hale said, in any event, once the argument departs from purely medical considerations and involves value judgments of this sort, it becomes clear, as Lord Kerr and Lord Reid conclude at paragraph 85, that the Bolam test of conduct supported by a responsible body of medical opinion becomes quite inapposite. Now, the importance of what she's saying there is when she says, once the argument departs from purely medical considerations, and the argument is essentially that in assessing what should have been known to a body of medical professionals, the test is Bolam, i.e. would a reasonable body of medical opinion have known about this risk? Now, that's a very important point which has been made. And again, think about the different circumstances in which this could arise. Going back again to a GP, is the advice which a GP provides going to be the same as an advice provided, for example, by an oncologist, an orthopedic surgeon, a cardiologist? Clearly no. A GP is a general practitioner, whereas orthopedic surgeons, so on and so forth, are specialists. It is axiomatic that the specialist will have a higher degree of knowledge in respect of the area in question. I do think that that will be an interesting and difficult question for the courts when assessing advice given by, for example, GPs. So if the claimant was not informed of a risk, in assessing whether or not that risk should have been brought to the claimant's attention, Lady Hale is suggesting in paragraph 115 that once you move away from medical considerations into a value of judgments, that's when Bolam does not apply. I have to say that that point hasn't been picked up by any of the appellate courts to date, so it is something which remains live, for a want of a better description. Now, is Montgomery limited to consent? This really is a very difficult question. There is a body of case law which suggests which Montgomery, the Montgomery approach applies to advice provided by clinicians, but at the same time there is conflicting case law. Draw your attention to the decision in Kennedy and Frankel, where Mrs. Justice Yip said, the advice which the defendant gave is to be considered according to the well-known test set out in Bolam. Clearly stated there. Now, Kennedy was an interesting case. It involved the prescription of medication for Parkinson's disease. The claimant developed a consequential behaviour disorder. The court found in favour of the claimant that she should have been advised about other drugs, but that the reduction in dose, that a reduction in dose should have been recommended. Kennedy is well worth reading, given that it considers both Bolam and Montgomery, but it's that clear quote from Mrs. Justice Yip that the advice which the defendant gave is to be considered according to the well-known test of Bolam. Contrast that to the decision of Webster and Burton Hospitals. That was a cerebral palsy case. There was an admitted negligent failure to carry out further scanning in response to poor fetal growth, asymmetry, and polyhydramnios at an antenatal scan. The question, given that it was admitted negligence, was what would have happened in the scenario that a scan had been performed, which would have shown reduced fetal growth. The claimant argued and alleged that it would have resulted in advice for early delivery. The defendant alleged and argued that it would not have resulted in advice for early delivery. And in the Court of Appeal, Lord Justice Simon said this: without intending to summarise the effect of Montgomery, in general terms the doctor's obligation, apart from in this case where this would be damage to the patient's welfare, is to present the material risks and uncertainties of different treatments and to allow patients to make decisions that will affect their health and well-being on proper information. The significance of the risks and uncertainties, including the possibility of alternative treatment, being sensitive to the characteristics of the patient. So in Webster, the court was saying that the claimant must be, in giving advice, they must be informed of all of the different options of advice. And so Webster was a first instance decision, in first instance, before Montgomery, and that was the importance. But then Montgomery was handed down by the Supreme Court, and that's why it went up to the Court of Appeal, who found for the claimant based upon the decision in Montgomery. So that's important there. We have the Court of Appeal decision, which is effectively applying Montgomery to advice cases, because what would the advice have been as the causation argument ran? Cases of pure advice must be distinguished from those where there's competing treatment options available. We'll come on to discuss this in a moment. So take the example of advising on realistic alternative medical opinions. This would be in a case where there's a school of thought among clinicians and medics that treatment X may benefit you. The thorny question is whether or not claimants should be informed about a potential treatment that maybe is not clinically recognized yet, if it's in the early stages potentially, or whether claimants should be informed about much more, I say, peripheral treatment. Obviously, I'm not talking about any treatment that's not clinically sanctioned or recommended. This would be cases whereby there is a much smaller school of thought that the claimant may derive benefit from that. Those will be difficult cases. Now, I just wanted, before we do move on to diagnosis and treatment cases, to talk briefly about the recent decision of Mr. Justice Ritchie in CNZ and Bath hospitals. The claimant was born on the 3rd of February 1996. She was the second of twins, her mother having delivered the first twin vaginally at 1 minute past midnight. By 27 minutes past midnight, the claimant's head had still not descended into the pelvis, and the mother's cervix was closing. At 35 minutes past, the attending obstetrician, who was a relatively inexperienced registrar, discussed the case with her consultant and decided to perform an artificial rupture of the mother's membranes. The mother objected and asked for a caesarean section. At 52 minutes past, the registrar obstetrician had a further discussion with the consultant, and at 3 minutes past 1, the claimant was delivered by caesarean section. From approximately 12:50 until 3 minutes after her birth, the claimant suffered acute profound hypoxic ischemia, and she was left with significant brain damage. So, continuing with the decision in CNZ, I do recommend that you read it. It's a lengthy judgment, but it has an excellent summary of the law of causation. So I do recommend that you read it. But so far as today's talk is concerned, I just wanted to focus on what Mr. Justice Ritchie said as regards Montgomery. He said, this decision, that being Montgomery, clarifies in arrears the requirements in law for clinicians when they are consenting patients. It applied to the 1999 events in the case, but how far back is it to be taken? So it was Montgomery, the birth was in 1999, and obviously the Supreme Court found in Montgomery that the consent law as it was ran from 1999. So the question that was posed was, so does Montgomery apply to the facts of this case in February 1996, 2 years before the passing of the Human Rights Act and before the internet had really developed much? I admit that I am troubled by this. I consider that it probably does. I have considered whether a watered-down form of the ruling should have applied, or whether a tapered growth of the Montgomery duty to consent properly could be the correct approach in 1996, but I do not consider I am permitted to do so as a court of first instance without an indication for such in the Supreme Court's judgment. So what Mr. Justice Ritchie has done there is he has said that Montgomery actually applied from February 96, and that really is quite a remarkable judgment that he's given, because when you think about it, that would have mean, and does mean, that doctors who were giving Bolam compliant advice in 1996 were proceeding upon what they knew and understood to be the law at the time, and were effectively acting in a reasonable manner, but are now potentially going to be held to be acting in a unreasonable manner. So it's quite a profound change that Mr. Justice Ritchie has introduced, and as he very correctly and fairly states, that he is troubled by this, and I don't know if this is being appealed, but there very much is an indication that the Supreme Court should reconsider this. Whether it gets that far will remain to be seen. So the consequences, as I say there, was that clinicians who were proceeding as competent clinicians at the time now find that their approach would not be Bolam acceptable. Okay, let's look then at the other major area where there's been a move away from Bolam negligence, and that is cases of pure diagnosis and pure treatment. And this is the line of authorities that lead up to the decision of Mr. Justice Kerr in Muller and King's College Hospital. Now, the case concerned the negligent interpretation of a histology slide. The claimant was diagnosed with an ulcer when in fact the slide showed malignant melanoma. Just quoting Mr. Justice Kerr, he said, the first type is a case such as the present, where the patient's condition is unknown, and what is alleged to be negligent is a doctor's diagnosis of the condition in the form of a report with no decision made or advice given about treatment or further diagnostic procedures. The diagnosis is either right or wrong, and if wrong, either negligently so or not. The case should be called a pure diagnosis case. At the other end of the spectrum is the second type of case, a pure treatment case, where the nature of the patient's condition is known and the alleged negligence consists in a decision to treat or advise treatment of a condition in a particular manner. The second type of case is the paradigm for application of the Bolam principle. Again, it's a decision that's well worth reading in full, and cited in the decision of Muller is the decision of Peeney and East Kent, which was a Court of Appeal decision, and that was a case which involved the misdiagnosis of cervical smears. And Lord Wolfe, Master of the Rolls, said the Bolam test has no application where the judge is required to make findings of fact, even where those findings of fact are subject to conflicting expert evidence. So what, having looked at that, continuing to consider Muller, Mr. Justice Kerr said, I have had to review that case, Peeney, case law in some detail in order to draw from it with some regret that the conclusion that even in a pure diagnosis case such as this, the exercise of preferring one expert to another must be viewed through the prism of the Belitho exception rather than, as would be preferable, by rejecting the very notion that the Bolam principle can apply where no Bolam appropriate issues arises. In a case involving advice, treatment, or both, opposed expert opinions may, in a sense, both be right, in that each represents a respectable body of professional opinion. The same is not true of pure diagnosis case such as the present, where there is no weighing of risks and benefits, only misreporting which may or may not be negligent. The experts expressing opposing views on that issue cannot both be right, and the issue is par excellence a matter for the decision of the court, which should not, as a matter of constitutional propriety, be delegated to the experts. So what that means is, in a case of a pure diagnosis case, the claimant must establish factually what the case is. For example, does an X-ray show a fracture? Yes or no? And then second, did the treating clinician, the radiologist, histologist, whoever, exercise reasonable care and skill in reaching their conclusion? Now, this again raises very difficult questions because in an obvious case, such as an obvious fracture to the arm, reasonable care and skill will be obvious. But what about cases where, as a finding of fact, yes, the fracture is apparent, but it is certainly not clear, it is ambiguous, and there could be reasonable competing opinions. Now, as was said by Mr. Justice Kerr, you must view, and in determining reasonable care and skill, it must be viewed by the Belitho exception. He didn't want to say that, but he felt compelled to do so by virtue of the state of the case law. The question really is, can it realistically be said that Bolam has no application in cases of a mistake or a mishap? Cases of neuroradiology are particularly contentious, and there may be competing opinions about whether or not the fact that the damage in question was not seen, whether or not that was reasonable. The court will struggle to answer whether or not reasonable care and skill has been exercised without the input of experts. So whilst, yes, it is a question for the court to ultimately decide, the court will have to be guided, at least to some extent, by what the experts are saying. Take another example, which is time constraints, and this is particularly important with NHS litigation and the state of the NHS at the time. Consider a case where you're reviewing CT results and there's over 2,000 slides of to review, and in only one slide does it show, the cancer. The defendant cannot simply say and argue that their behaviour is excused simply because other clinicians would have made the same mistake. That would fall foul of Muller. But can they argue that they deployed reasonable care based upon the time constraints in question? That's an interesting argument, and one which I think is open to the court to consider. Okay, so let's see if we can just take some examples to really flesh out what we've been saying here. Failure to warn of a material risk of surgery. That's clear and obvious. It's the Montgomery case. Failure to offer a reasonable alternative medical treatment. It's pretty clear and obvious. It's going to be Montgomery. Advice given based upon clinical results. You're looking at Montgomery, but then remember the decision of and the comments of Mrs. Justice Yip in Kennedy. But what about this one? Advice which is given is accepted to be Bolam reasonable, but did not discuss a potential investigation for which there was no clinical indication. And that was the question and the issue of which I did a trial on last year, where the claimant went for a cardiac stress test to renew his DVLA HGV license. The judge accepted that the advice which was provided by the cardiologist, which was that there was no indication based upon the results of his test for any further treatment, was reasonable. But the judge found that there was a breach of Montgomery in failing to offer an investigation, ultimately leading to revascularization. That was a difficult decision, so the judge's judgment did not sit easily, but because he found that the advice which was provided was Bolam reasonable, he then imparted a Montgomery duty upon the claimant that he should have discussed further options with him. But the claimant declined to take him up on that invitation. So the cardiologist had no opportunity to discharge the obligation and the duty which the court had imposed upon him. But yeah, it was a difficult but interesting case in which there was a clear extension of the principle of Montgomery. Consider this, an X-ray as an example, an X-ray performed which shows a clear fracture. That fracture is not diagnosed. That's obviously a Muller case, a pure diagnosis case. And then consider the example of a CT scan which reveals a potential bowel tumour. It's not identified. It's accepted that on the balance of probabilities it does show a tumour, but there's difference of opinion between experts as to whether or not the report is negligent. Muller, obviously, because it's diagnosis, but what room is there for Bolam, bearing in mind that the Belitho exception is retained as per Muller. Okay, so let's see if we can draw any conclusions to this. Then, advice on treatment options. I think we can all safely say that's a Montgomery situation. Interpretation of tests or investigation. You'll be looking at the decision in Muller, reasonable care and skill, but as I stress, with the Belitho exception. And management of a condition, including investigations, diagnosis and treatment. That's going to obviously be a Bolam case. And then consent to surgery in the classic sense is, of course, a Montgomery decision. So I hope you found this talk beneficial. It's a very interesting area, and it's often easy to overlook the importance and significance of Bolam in cases. So I do think it's worth thinking very carefully about Bolam and its application to the case that you are looking at, either as a claimant solicitor or as a defendant solicitor, and consider and stress test whether or not the principles of Montgomery or of Muller apply to it as well. So thank you very much for your time then.